Your home could be stolen from you, not broken into, stolen. And if you are a UK property owner right now and you have not put these property protection steps in place, you are vulnerable to fraud, to losing your home to care home costs, and to the council having a claim on your property when you are most vulnerable. I'm Rubina, a qualified accountant and tax advisor, and in this video, I'm going to walk you through 5 things every UK property owner needs to do, from registering with HM Land Registry to setting up a lasting power of attorney to understanding tenants in common versus joint tenants, because the wrong setup could cost your family tens of thousands of pounds. I have seen families lose serious money over this. So, if you own property in the UK, stay with me. Quickly hit subscribe now so you don't miss the rest of this series, because this channel is all about helping you protect what you have built. Let's get into it. Register with HM Land Registry. The first thing and the simplest is to make sure your property is registered with HM Land Registry. Property fraud is one of the fastest growing forms of financial crime in the UK. Here is how it works. Fraudsters impersonate you as the legal owner, then try to take out a mortgage or a loan secured against your home without you knowing a thing. Your solicitor should have registered your property when you bought it. But here is what most people don't know. Around 15% of land in the UK is still unregistered. That is usually inherited properties or properties bought a very long time ago. So, step 1, go and check. And even if you are registered, make sure HM Land Registry have your most up-to-date email address. Because if someone attempts to change the ownership of your property or make any kind of application, you will get an alert. That email address could be the thing that saves your home. Sign up for the Property Alert Service. Once your property is registered, you need to actively sign up for the free Property Alert Service through HM Land Registry. Just being registered is not enough. You have to opt in to receive the alerts. Now, property fraud is still relatively rare, but the consequences can be catastrophic, and certain properties are much more at risk. Empty properties, rental properties, homes without a mortgage, and inherited or trust-held properties. Why are unmortgaged properties so vulnerable? Because there is no lender actively monitoring the title. There is no bank double-checking things. It is just you. This alert service won't prevent an attempt, but it means you will know about it fast enough to act. There are real cases where people caught fraudulent mortgage applications in time because they were on this service, and it is completely free. There is no reason not to do it. Consider a Form LL restriction. This one is more niche, but if it applies to you, it matters a lot. A Form LL restriction is a legal protection that requires a solicitor to certify that the person trying to sell or mortgage a property is actually the legal owner. It adds an extra verification layer that criminals can't easily bypass. This is most useful if you leave your property empty for long periods. Maybe you travel a lot, you have a second property, or it is a rental. It is also worth considering if you are older, you have accumulated significant assets, and you are perhaps becoming more dependent on others to manage things for you. Organized criminals do specifically target the most vulnerable properties and the most vulnerable people. This restriction is a way of making your property a much harder target. The trade-off: it can slow things down if you want to sell or remortgage, because you will need a solicitor involved to verify your identity. It is not for everyone. But if any of those risk factors apply to you, it could give you real peace of mind. Set up a lasting power of attorney. This is the one that people delay the most, and it is one of the most important. A lasting power of attorney, or LPA, is a legal document that lets you appoint trusted people to make decisions on your behalf if you lose the capacity to do so yourself. And there are two types, one for health and welfare and one for property and financial affairs, which is the one we are focused on here. With the property and financial affairs LPA in place, the attorney you appoint can manage your finances, pay your bills, and buy or sell property on your behalf. Without it, your family may not legally be able to help you, even if you are incapacitated, even if you trust them completely, even in an emergency. They would have to apply to the court of protection, which is expensive, slow, and deeply stressful. And please, don't think this is only something older people need. If you were in an accident tomorrow, if you were diagnosed with a serious illness, would the people you trust most be able to step in and manage your affairs? Without an LPA, the answer might be no. Set one up before you need it, because once you lose capacity, it is too late. Understand joint tenants versus tenants in common. This last one is where it gets really important from a financial planning perspective, and it is something most couples in the UK have never thought about. Right now, I want you to hold this number in your head. £5,200 per month, that is the average cost of residential care in the UK. Nursing care, £6,100 per month. And I can verify those numbers. I have worked in the care sector. Now, here is the problem most people don't know they have. Most couples in the UK own their home as joint tenants. That means when the first spouse dies, 100% of the property passes automatically to the surviving spouse. That is called the right of survivorship. Here is why that becomes a problem. In England, if your total capital is over £23,250, you are expected to fund your own care. The council will not help. When the first spouse needs care, the local authority will disregard the second spouse still living in the home. So that is fine. But when the second spouse eventually needs care, they now own 100% of the property. The full value goes into the means test. And most people will be forced to sell their home or enter a deferred payment agreement with the council, who will sell it later to settle the bill. Tenants in common works differently. Each spouse owns a defined share, usually 50-50, and if you pair that with a properly drafted will and a life interest trust, the share of the first spouse to die can be ring-fenced. It passes into the trust. The surviving spouse can still live in the property, but they only ever own their own share, not the whole thing. So when that second spouse eventually needs care, the full property value is never all in the means test. That is how families protect their wealth across generations. I do need to be clear here. Changing your ownership structure can in some circumstances be viewed as a deliberate deprivation of assets, particularly if it is done close to when care is needed. So you must take paid legal advice before making any changes. This is the education, not the implementation. That is it. 5 things every UK property owner needs in place to avoid property fraud, protect against rising care home fees, and make sure your lasting power of attorney and tenants in common structure are actually set up properly. If this helps you understand how to protect your property in the UK, hit subscribe. It costs you nothing, but it helps this channel keep making content like this. And drop a comment below telling me which of these 5 you did not know about. I read every single comment. I will see you in the next video.